Hey, I cannot hear anything.
Because I'm not talking, just remain silent and mute it until your case is called, please.
Sorry, ma'am.
Sounds like you have a hearing. You're not hearing what's going on.
I don't have the summons. My son was.
Okay, I'm gonna stop you there. Who are you?
My name is Rayanne Burke. I have the durable power of attorney for Richard Ball.
Okay, I haven't called that case. Are you having trouble hearing?
I
Okay, can you get her hearing device?
apologize.
No, that's fine. I'm just trying to get you a hearing device.
So frustrating when you can't hear anything.
Okay, this is on for a motion for contempt. I had set it over with the idea of getting medical records. That hasn't, other than some basic information, that has not occurred. But the bigger issue is I went back and read your request and clarify, are you asking for jail time?
Yes, I do.
Okay, then you have a right to an attorney. Do you wish to have an attorney?
Yes.
Okay, all right. So with that, we are going to have to locate an attorney that will represent Mr. Jackson on this matter. And how do you say your first name? Elazar?
Elazar.
Okay, Mr. Jackson, and that needs to occur before we can go forward on the contempt matter.
Okay.
Okay, so I know you already have an order. I know your issue and concern last week was you're homeless. I understand that. You have an order already that gives you the right to the possession of the house. How you pursue that is up to you. But meanwhile, on the contempt part of this, we will try, court administration will be the ones that locate an attorney for you. I don't know how long it will take. I expect that it's going to take a while. And so in regard to the contempt matter, we are going to set that over to April 23 at this time in hopes that an attorney has been located to represent Mr. Jackson. So Mr. Jackson, what will happen is, if you like, Autumn Terry is the person that will be locating an attorney for you. You're welcome to reach out to her just to check in with her about whether she's located one. Don't expect it to happen real quick though, okay?
Okay.
But is all your contact information current in the court file?
Yes, ma'am.
Okay. So as long as your contact information is current in the file, then nothing will be happening here today until we get an attorney on board for you.
Okay.
Your Honor, one more question. For next week, the 9th, he set an appointment for a motion for a new family law. Are we gonna strike that for right now? Since we have the motion of contempt finished up?
The contempt is a separate matter, and that's the one that has the right to an attorney.
Okay.
In regard to whatever is set in front of me for next week, that's a separate issue, and we'll address that separately. So continue as if that part of it is going forward.
Okay, thank you.
Okay. All right. All right. So with that, there will be nothing more today. And like I said, reach out to court administration, Autumn Terry, if you'd like to find out if an attorney's been located.
I have she has a no contact order, which keeps her from being at my house. And that's why she's not there right now.
Okay. I'm not going to address anything else at this time. I'm not addressing the contempt matter. I'm not addressing anything that you have on for next week. I've addressed the one issue that I wanted to take care of today, which is to tell you have a right to an attorney and see if you want one. And then attorney will be figured out, and then we'll go from there.
Yeah, because the restraining order says something that we.
Okay, ma'am. So
So the 23rd for the contempt at this point?
correct.
Okay.
That's assuming an attorney is
Ramos
located.
and Okay.
V. Ramos, I see we have Mr. Baldwin and we have Ms. Winkles.
I'll tell the court, our notice of appearance is being filed today in this matter, Your Honor. There's a number of other matters ongoing involving Mr. Ramos and Miss Shirley and his current wife in domestic case and 2 protection order cases, as well as a criminal case. Our notice of appearance didn't get filed in this matter, we realized this morning, so it's getting filed today. I believe there's an agreement to put the matter over 2 weeks. Is that correct, Ms. Winkles?
That's correct. Whenever the next open docket is.
Okay, that would be April 23.
Ooh, okay.
Thanks. My only question, Your Honor, I don't know, Ms. Winkles, we were trying to communicate this morning. The other domestic matter with Mr. Ramos and some similar issues, as well as both protection orders, there's a DV protection order filed by Ms. Shirley, are currently in front of Judge Basher. I don't know if the court would want this to be on Judge Basher's docket because he's hearing all the other matters. I'm indifferent, but I wanted the court to be aware that there were those other cases that he's currently hearing that directly involve or are related to these parties.
Ms. Winkles, I don't
have any issue whatsoever with either Your Honor or Judge Basher hearing it. I will say it's the same father in both and the same criminal action in both. So it might, I'm not sure if they want to hear them together or if that's prejudicial in any way because the children are vastly in different ages. So I have no issue.
This is,
if it's in front of Judge Basher, because it sounds like he's already hearing something that's connected to it. And I'd rather be heard together and have the same factual backgrounds than different. So.
And there's already a GAL in the other case, and we can get that same person appointed in this case or something like that. That works for me.
All right, that makes more sense. So let's go ahead, and then it would not be set out to the 23rd. When is that matter on?
it was heard last week. I don't know if there's a current date set. If we could just put this 2 weeks, Your Honor, given that it's new filings, and then we can get things on the same track. I don't want it to get lost and set way out. As I said, there is also a DV protection order filed by Miss Shirley, I think probably alleging similar facts as in this action. So, and that's also in front of Judge Basher on a different docket day. I think it's appropriate to be in front of him. If we could do 2 weeks, that gives time to try and get everything sorted.
All right. How about we go ahead and set it April 16 at 1 o'clock in front of Judge Basher.
All right, that works for me.
I did want to talk about the ball and ball matter. Ms. Winkles.
Yes, Your Honor. We don't have proper service.
Okay, so strike it.
I would ask that it be set over because there is a restraining order in place. I just ask that it be set over 2 weeks. He has been served now, but I would like to give him the full 20 days or 3 weeks, April 23rd, whenever your next available is.
Okay, I have a lady here that's claiming to have a power of attorney in this matter.
And I would argue that it's not the same as litigation GAL, and it's not appropriate for her to stand in the place. The power of attorney doesn't do that. It doesn't give you the right to litigate. It can give her the right to hire an attorney, but it wouldn't give her the right to act in his place.
Let me see your power of attorney. All right, reviewing the power of attorney, the court does not find that it gives you the ability to stand in essentially as an attorney acting on behalf of Mr. Ball. You can certainly retain an attorney or do something of that nature to represent him, but I do not find that it's.
Your Honor, my son is indigent. Alicia has taken control of all assets.
Okay, ma'am, I'm going to stop you right there. You have no right to speak on his behalf. So even if he's indigent, this is a civil matter that doesn't give him a right to an attorney. So that's not going to be happening today. Service wasn't made. It's not going to happen today anyhow, other than the restraining order is going to be continued. Ms. Winkles, can you get me a restraining order to sign off on?
I will. I'll get it to you by the end of today.
And it appears that this needs to be on the 1 o'clock docket, not I think it got set on the wrong docket.
Okay. What's the next available one on the 1 p.m. docket? I'm trying to think. We served him. Actually, I guess it would be the same week. So still the 23rd at 1.
Well, no, for his dockets, I don't know what is or isn't closed. I'm not aware of his dockets being closed. Mine are full, so it could be over next week to Tuesday at
I
1.
don't think that's enough time for service.
Okay.
So I think in this case, we better just put it on the 23rd.
Okay, so make sure your restraining order has that.
I will do.
All right,
All right. Thank you, Your Honor.
all right.
Can I speak?
No, we're done.
I'm named in that restraining order, Your Honor.
Okay, well, it's an ex parte restraining order that hasn't
Accusation
been
made against
served.
me.
I'm not, Miss Winkles, are you there?
Yes, Your Honor, I'm here.
This woman is saying she's named in the restraining order. I'm not aware of that.
She was just named in the declaration by my
You're named in the
client.
declaration, that's it.
I'm sorry.
You're named in the declaration, you're not named in the restraining order.
I apologize. I don't understand exactly what that means.
The statement they made in the restraining order has your name in it,
Yeah, she
but
claimed
you're
that was
not
on the property.
restrained by the restraining order.
I'm not restrained by the restraining order.
No.
Oh, okay. All right. We have no way to hire a lawyer.
Beth Fellows, GAL, is present.
Abby, just a second. All right, Mr. Zandy? Oh, yes, Mr. Zandy's here. Ms. Holder? Mr. Zandy, did you receive any information? Because I did not.
I didn't, Judge, and these, again, this is one that was a short set from last week. We got the orders out on the 27th. I did email Miss Holder today at about 8:06 a.m. to see if there was any objections to the proposed orders. I didn't get a response prior to logging in today, so I'm not sure where that really leaves us. I didn't get any written objections and have not had contact with Miss Holder since the hearing.
Do you want to contact her maybe? I can recall it.
Yeah, that's fine. I'll stop my video and mute myself and try to give her a call and see where we're at.
All right, sounds good.
Morning, Your Honor.
Yes, Your Honor. Good morning.
Keith Lawrence, guardian ad litem.
Okay. All right. Mr. Trotter? Oh, okay, I see you there.
Good morning, Your Honor. Sorry about that.
Good morning. All right, proceed with your request.
Yeah, it was my understanding we're here, and correct me if I'm wrong, we're here on a review, and then also parenting plans were submitted. And so we've reviewed the GAL report. We accept those recommendations. And essentially, if it's with respect to the parenting plans, those recommendations or the parenting plans align with the GAL's report. In particular, the piece about the reunification counselor being the one to decide when the parties are to reunite, whether it be for therapy or for the long-term process. So I guess if those are the issues, would be the GAL report.
So the review is actually requested by Mr. Johnston.
Okay.
Yes, Your Honor.
The report was filed some time ago, September of 23. And so this is the first time this matter's been brought before the court to make the request. Mr. Johnston he called it a review, which is really a motion, if I understand correctly, Mr. Johnston, to adopt the recommendations. Was that it?
Yes, Your Honor.
Okay. So, Mr. Trotter, am I hearing that you're not objecting? Your client's not objecting to that?
That's correct, Your Honor.
Okay. So it sounds like there isn't an objection to that, Mr. Johnston. So if that's the case, then let me hear from the guardian ad litem.
Your Honor, I've had a chance to review the declarations of both parties. I'm pleased that they are willing to go along with my recommendations. I think that due to the mental health issues and the stress and strife that's been in the home, that my recommendations cover all of the areas of need.
Okay. All right, well, if it's agreed upon, I'm not sure there's really anything I need to do at this point, other than you need to prepare an order that has a parenting plan that meets all the requirements and get things moving forward so that Mr. Johnston can start moving forward to have contact with the children.
Yes.
And just for the record as to what, let me get back to the guardian ad litem's report. That Jennifer Johnston remain as a children's custodial parent, that joint decision-making authority be imposed, that Joshua Johnston seek psychological help for PTSD and domestic violence through the VAA or other qualified counseling agency, that Joshua Johnston abide by any treatment recommendations, that Jennifer Johnston also seeks psychological help for counseling dealing with her relationship with the children, that the children also seek psychological help for dealing with the divorce, their mother's involvement with a particular company and their relationship with their father, that Joshua Johnston be reintegrated into the children's lives by starting with reconciliation counseling, that the counselor be granted the ability to recommend telephone visits, video visits, in-person visits, depending on the progress of the counseling and Joshua's compliance with recommendation, and that Jennifer Johnston not share any further information about her work with, I guess it's called OnlyFans, with the children, that neither Jennifer Johnston nor Joshua Johnston expose the children to any new romantic relationships for 6 months, that neither party speak derogatorily about the other party in front of the children. So I reviewed the report. That appears to be appropriate other than the joint decision-making. I don't want to have joint decision-making yet. I want to wait until Mr. Johnston's having the visitation so he knows the children, knows what their needs are. I'm just not sure it's at that point yet. So I think that's something that, again, the reconciliation counselor can maybe weigh in on. But if not, then once you have in-person visits, Mr. Johnston, I don't have a problem with you getting that joint decision-making. I just want you to know the kids again before making decisions about what they can and can't do.
Understood, Your Honor. Also, I submitted a proposed parenting plan. It included some differences in the plan submitted by Mr. Trotter. Mainly one of the differences was to include Jennifer's counseling as a stipulation for mental health. And I asked that you would sign that so we don't have to do another or submit another order.
Let me see
With the exception of the joint decision-making. I'm sorry, Your Honor.
Yeah, I don't think we would object to that because that's one of the recommendations.
Do you know when you submitted it, Mr. Johnston?
I believe it was either March 18th or 19th.
You know, I may have it in the file here. I do have it. I just had it set aside in the wrong place. So looking at Mr. Johnston's proposed parenting plan, oh, there it is. I'm on page 3 paragraph 5A, the X's that are under joint, I'm going to go ahead and white out. And that leaves Jennifer Johnston marked there. And then,
Well, we got $8 worth of winning lottery tickets.
excuse me, please mute your connection, whoever was just talking. All right, so I put an asterisk under 5A and behind the name of Jennifer Johnston, and then the asterisk with a sentence, this can be joint once father has unsupervised visits with children.
Thank you, Your Honor.
Agreed.
All right. And otherwise, Mr. Trotter, are you okay to put approved via Zoom on this?
Yes, Your Honor.
All right, Mr. Zandy, did you get any response?
I did, Your Honor, and spoke briefly with Miss Holder, who informs that she has agreed to the form of both orders, that being the order on adequate cause as well as the order appointing the GAO.
All right, and is she okay to put approved via Zoom, do you know?
I got that. I did not ask her specifically, but I got that impression. She did indicate that she had some signed orders that she thought had been delivered to my office, but apparently a paralegal was sick in her office, and therefore she's not sure what happened to it. But nonetheless, there was no changes, and she's agreeable to what we presented.
Was that via telephone? And I'll just put that.
It was.
This is Beth Fellows, the GAL. I did receive my appointment orders from the clerk's office yesterday.
Okay. Because I have one on here. Okay. Well, if you receive that, then it looks like the only thing I need to sign off on is the order on adequate cause. So I've signed off on that. And Mr. Zandy, I will not be signing off on the other order.
Yeah, what I assume what probably happened is I sent signed orders over to Miss Holder. So I assume that she probably just signed that and had her staff enter it directly with the court, but that doesn't explain the order on adequate cause. But nonetheless, sounds like that's agreed and get this processed.
Okay.
Very well. Thank you.
All right. Thank you. All right. That brings me to the final matter, Grounds and Bob matter. Okay, we have Mr. Bob, we have Ms. Winkles, and who else did we have?
This is Mandy Grunitz, Your Honor.
Okay. All right, Ms. Winkles.
Yes, Your Honor. Just a little background. We served our first ROGs in this case on 9/27 of 2023. That meant they were due back on 10/24. We had a CR26I conference held on November 13th. We extended it to 1/17. We received a little bit on December 12th. We received a couple more on January 5th. I did another CR26I on 1/3, extending it to 1/17. Held another conference on 2/12, CR26I, extending it to 3/4, trying to give as many chances as I can. We have received nothing essentially since 1/5. I even gave her access to a Dropbox file so that she could just load them up. I offered to give her a flash drive to put them on. I offered to stay open late. There is no more that I can do. I don't have residential address. I don't have employers. I don't have anything about her mental health history. I have lots of reserved with no proper objection. I am missing about, I believe it's out of all of the interrogatories, I am missing 68% of them, over half. And the ones that I'm missing are the ones that are vital to this case, namely what community asset she's claiming, what community debts she states she has, what her income was during that time, anything about a ring, anything about a committed intimate relationship. Essentially every single thing that I have waited, almost, I don't know, 5 more months. So it's been almost 7 months now waiting for this stuff. I can't move it forward to trial. We're done. We submitted all of our discovery, every single answer, and we provided it. We mailed it. We even had, I believe, a courier is going out there with it, even though it's huge. And we submitted it in Dropbox for her. She claimed she couldn't access it anymore. I set up another one. She claimed she had no access to that. I set up another one. At this point, I'm throwing my hands up because I don't think I've ever been quite this nice and friendly and accommodating to anybody in discovery, and I can't do anything. My client's just waiting. This will never go to trial. When we call her, she says she's making a spreadsheet or she's doing something of that nature. She's consolidating it. I don't need what she consolidates. What I need are the actual documents that come from the bank, the retirement, the employer, those things. So I'd ask that you find her, that you compel her, that you assess attorney fees in this case, because that seemed to be the only thing that worked in our other cases, that we set a review for 2 weeks, and that if she doesn't turn it in by then, you strike her pleadings. And I'm hoping that will spur her on to actually get us the documentation that we need. I don't even know what her current employer's address is. I know absolutely nothing that is useful. All the questions she did answer are the ones that are somewhat useful, but they're not useful in me making a spreadsheet of assets and debts so we can finally dissolve whatever relationship they had, be it a CIR or be it friends or be it whatever it was. I can't move it to a trial. It's just going to continue to languish.
All right, Ms. Grounds,
Yes.
anything you'd like to say?
Good morning. Yes, I do have some things to say. I intended to bring up a lot of issues. However, I have had a chance to overview my breakdown of projects at hand. This case has been agreeably one of the most daunting cases I've ever had to work on. My background is finance, accounting, and contracting. That's where I excel, and this last year has been an attempt to navigate the court system. It is not my professional arena. I've had to do a breakdown of 2024 and determine where my time is most valuable, and that is actually making magic for my clients, the people who want to pay me to show up and are willing to do it without a fight. So I have this case will need professional assistance. And I've delegated the elements of this, distributed the elements of this case to the proper professionals so that Ms. Winkles can get her authenticated reports that she needs and her court compliant reports that she needs to actually carry forward on this case. So, as pro se, I'm accustomed to mediation. That isn't going to be an option. I've offered resolve without any damage to Mr. Bob's credit or credibility to date, but I'm faced with financial reporting due. April 15th is tax reporting. This is my employer for the last 2 years. I don't know my income because we haven't had a chance to actually discuss it. So I have to put in my financial statements to the professional financial auditing team, and they can help me determine what that income is, and then I can get that report to Ms. Winkles. And that's been submitted. I am filing an extension for my taxes by 6 months to figure out what it is I'm claiming for an employee wage versus the CIR interest in reimbursement. I haven't disputed any of the assets, and he has all the assets, and he has access to all the assets. He can go get whatever he wants whenever he wants it. His nephew's on the property, he wants something, go get it. Go find it. When I get a chance to tackle that project, I will happily return whatever I have, but what he wants. That's not on my priority list right now because I have clients waiting in queue who want my attention, and I have to offload all the other, anything I can delegate. So the first one's finances because that's the holdup. Second one is legal counsel. My forms have not been court compliant because I have not wanted to counter respond in any damaging way. The reports I am now faced and forced to have to submit because of the position this issue has brought me into will be damaging or could be damaging, and those will be done by professionals so I don't mess it up. That's not my arena. I hand that over to the legal team to address, and they are waiting. I'm awaiting a response on who's going to take lead on this case. I have submitted discovery. It's been used to threaten me and intimidate me back. I have a legal dispute, and it's going to need professional attention. That's in the works. This case keeps coming forward by counsel as a dispute about assets or a dispute about money even. I'm in a position where I claimed an income for 2022 I didn't earn. So
Stop.
I have just three more statements. Please let me finish.
Stop.
Winkles. This is about family law. This is about my children.
Unless you
My
want to go
children
right now and go to jail, stop.
What?
I asked you to stop. I expect you to stop. I've allowed you.
May I have a
All right. I have asked you to stop. When I asked you to stop, I expect you to stop. I get when people are on Zoom that somehow they think that the court rules don't apply. They do. I've allowed you to go on about things unrelated to the motion before this court. This is only about discovery. It's not about settlement. It's not about what he can come and get. It's about none of those things. So I'm done hearing things that are not relevant to what we are here about here today. If you want to say a couple of sentences that relate to what we're here about today, then I'll let you say it, but I'm not going to have you go on and on. Is there anything else in regard to the discovery? Only the discovery.
My discovery is delinquent due to the fact I've dispersed it to professional teams. I'm awaiting their reports to give to Winkles. I'm asking the courts to give the time for the financial team to report back to me what the issue is that Winkles trying to address is the income. She's seeking this information. I am trying to get it to her.
Ms. Winkles?
Yes, I'm not sure what expert she's hired or why. Bank statements don't need an expert. Retirement, you call up a phone number. Employer, you write it down. All of these documents can be given by anybody. And she's had 8 months, 9 months to go get them. I've subpoenaed who I can, and I'll continue to whenever I find out, oh, she might have worked here. I'll continue to subpoena at great cost to my client. But the fact is, I don't need her expert report. That's the whole point of it, is we get the background documents and we hire our own expert. And then they can decide what is there and what is not. The fact is she's not compliant. And she's going to continually drag her feet. I've had 3 CIRs giving her plenty of time. And why did she hire? Let's just say this person has all of her tax documents and she can't give them to me because that's one of the things I requested. I'm not sure why she can't go on the IRS website and get it. It takes 5 minutes. But aside from that, our first CIR was back in November. And then we had another one in January and another one in February. And by the end of it, it was almost as if her dog ate her homework. Every time there was a different excuse. I couldn't go here. I couldn't get this document. This happened. At this point, I think that it's excuses and excuses. It doesn't make any sense. You can send a child into the bank to get bank statements. So I'd ask that Your Honor find that she has not materially answered these, that assess an attorney fee amount of $1,500. And if we could put it on review, and if she doesn't get them to me in 2 weeks, that her pleadings will be stricken. Because at this point, Mr. Boppis just keeps paying me to show up here and with a new excuse, and she has a new excuse every single time. Thank you.
So I reviewed the files and record and have heard what I've heard today. And based on the files and record, the court does find a 26I. And if you don't know what that is, that's Civil Rule 26I was set and the due date was extended. Additional extensions were made. There was some discovery provided, but none of the missing discovery as of now. Therefore, the court orders the compliance with the request for discovery. It does not require teams of people to put together the documents as indicated by Ms. Winkles. The discovery is to be no later. I'm going to put it on the 23rd, April 23rd, and with full and complete answers, or be subject to sanctions of possibly striking the petitioner's pleading or not allow the petitioner to testify regarding any information contained in the unanswered interrogatories. The court does grant the order of $500 in attorney's fees for the necessity of having to bring today's motion. That is to be paid within 90 days of today's date.
And presentation, can we do that first order on the 23rd?
We can.
Okay, perfect.
All right, that concludes this matter.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes this hearing.
See, Mr. I'm going to mute you, ma'am. We're getting some feedback. Mr. Anagnostou, present. There he is. And I think Ms. Day is also involved in this matter, the Winchester matter.
Yes, Your Honor, I'm here.
Good morning. I had a note here. We were waiting for a full guardianship to be filed on this one. I don't see that.
I was a little confused about that, Your Honor, because at the last hearing, I know we kind of bounced back and forth on whether or not the petitioners need to file a full guardianship. So this is a case, my client is in jail. She's expected to get out, I think in August or September. And we wanted to have this in place until after that point and then revisit it. The plan is to have the children return to my client's care once she's served her time. So I know we talked about a full guardianship, but I don't know where we ended up.
I think on the concern I have is that on the temporary emergency or the emergency guardianship, I can only issue that for a maximum of 120 days. So we've got really 60 days on this one, which we entered on. So it really, unless I extend it, it expires today. So.
Oh, okay. You can extend it for one 60-day period?
I think this was the first one of this. So we can extend this for one 60-day period.
And then the grandmother, Miss Glenn's, would need to file, I guess she needs to file a full guardianship.
Right, at which point we could extend it to any hearing set in that matter, and we could pick a date out beyond where your client could set up. But that's where we're at. I can extend this one out for 60 days, and then, but we will need to have a full guardianship filed if that doesn't cover the time period.
I believe she's present, so.
I'm here.
Good morning.
Good morning.
Do you understand what we're talking about here, I can own, this guardianship technically expires today. I can extend this for 60 days, which I can do just with a bench order.
Yes, Your Honor, please, because, if there's something happened to the kids, I would like to, take them to the hospital, doctor, or something like that. So I needed that extension custody or whatever it is.
So I'm looking at probably the 28th of May. And I can review it again at that time. If we have a full guardianship petition filed, and you may want to you may want to talk to Mr. Anagnostou about that, or possibly Ms. Day. I think Ms. Day has already been relieved, though, in this case.
No, I believe that the last hearing, the court ordered her to stay on.
Oh, okay. Okay.
Yeah, I remain on until the full guardianship moves forward. I think the difficulty Ms. Glenn's petitioner's having is how to do all that paperwork is very complicated. And so I'm hopeful that Mr. Anagnostou can help with just a petition and summons, making sure that she gets the right paperwork completed. I know the mother is in favor of the full guardianship being filed, only as in allowing for her children to be cared for by Ms. Glenn's until she is released from custody. Father, I think, is in the wind again, if you will, Your Honor. After being incarcerated, I think he's disappeared again.
Yeah, he's actually has a warrant of arrest right now, stealing truck again or something. So
okay. So here's what I'll do today. I'll extend this out 60 days. I'll set a hearing May 28th, which is about 2 months out, a little under, so that we don't run out of time. And if you could talk with Mr. Anagnostou and possibly Ms. Day, get the paperwork for the full guardianship filed. At that point, when we come back on the 28th, I can extend it out with an maybe just expect we're going to have a hearing sometime in September or something after Mr. Anagnostou's client gets out, at which point this could all be dismissed. But in order for there to be an order that I can make last that long, I have to have that other case filed.
okay, yeah, I have talked to him. I was there, I think, like two weeks ago, and talked to him about helping me for the paperwork filed out. So
okay. Well, those other documents need to be filed, or I can only extend it 60 days. And again, I'll go to May 28th at 10:30 today. Okay.
All right. Thank you, sir.
Excuse me.
Thank you, Your Honor.
You're welcome.
Thank you. Thank you.
And I think I saw Miss Winkles.
Yes, Your Honor, I'm here.
There we go. Okay, Mr. Anagnostou is here. Mr. Reisenberg is here. Where are we at on this case? Ms. Day is also present.
Oh,
Ms. Winkles, go ahead. You know where we're at.
I was just going to say procedurally, I'm not quite sure why we're here today. I know Mr. Anagnostou's client filed when he wasn't here. And I believe he filed something immediately before Mr. Anagnostou was appointed. So I think that part of it needs to be stricken. It's not not proper procedure. And I think at this point, we're actually moving, the guardian did file the full guardianship. The next step, we have that now. I think the next step would be for my client to go ahead and file, go onto the trial setting docket, unless Your Honor can assign us today to that. The other
we
thing
already have a trial set. There's a trial set.
There's already a trial set. Okay, I was gone last week, so I'm assuming that was set very recently. On the other, apparently there's already a trial set. The other thing is the parties in this case, mom and dad, are also in the family law action over a parenting plan, because I believe they both realize that the guardianship will probably come to an end. So there is that separate safety net. There will be, I believe they are having hearing. Mr. Anagnostou's in that one as well, so he would know more about that than I would. But I believe Miss Day has also been appointed in that. Yes.
She has, Your Honor, just recently. So there's a family law case between my client and the mother. In the family law case, Miss Day's been appointed to make a recommendation as to what should happen with this child. I mean, she's 16 and a half, something like that. I mean, And so it's an older child and has her, desires, wishes, those type of things are going to be taken into consideration. So the family law case is working through that process. And then we have this guardianship case with the relatives that live up north, I think in Toledo or Tootle, one of them. Anyway, so at this time, we just received the filing for the full petition about a week or so ago, and my client would need to respond to that. But the idea is that I think Miss Day is going to resolve most of the issues with regards to this child for all the parties.
And I'd agree with that, Your Honor.
So it looks like we've got a trial date set August 5th, which is a Monday. It's set for 2 days. In order to, I guess, minimize the continued return for reviews here, I could extend this order until, say, either the 6th or the 13th of August in hopes that it's resolved either at that trial or in the family law matter.
I think that makes sense, Your Honor.
Okay. So I'll do an order extending and I'll put in, I think I'll go the 13th. That's the Tuesday following the week of trial. That way, if the trial resolves everything, that can be stricken. If it doesn't resolve it, we'll have a case set that we can review this if we need to.
Sounds good, Your Honor. Thank you.
Okay, so do an order extending August 13th, 2024 at 10:30 will be our next hearing in this case.
And Your Honor, if we could address one other small issue.
Sure.
Ms. Winkles is going to be withdrawing from this matter and she's the child's attorney. We need another attorney appointed.
Oh, I'm mom's.
Oh, your mom's attorney. I thought you were
mom's
child's attorney.
Yeah, and that's not till April 23rd. We may already have this resolved by then. So I haven't asked, the court should be getting these pleadings, but I'm asking to withdraw on nearly half of my cases just due to my health and getting tired of having pneumonia. But it won't be till April 23rd, and it sounds like this is going to be till August 5th. So I'm sure I might actually be okay by August 3rd.
My apologies. I misspoke. Thank you for letting me know.
If it does appear that you need to withdraw and the mother wishes to have representation, if you could advise us of that, we can then appoint somebody to step in.
Okay, and you will be getting my pleadings in the mail, but the one thing is this case being August 5th, my doctor said 2 months of very little stress to allow my lungs to heal. I'm wondering if we're having this extend, I might be able to stay in on this case. So okay. I'll talk to my client about that.
Yeah, and I wouldn't, again, there won't be any more hearings in this case until August 16th, so.
And that's plenty of time. All right, thank you, Your Honor.
There you are, thank you. Thank you.
Good morning.
So where are we at on this one? I have a proposed order on this case.
I have not seen that.
I don't know what's going on with your machine. Do you have two different, sometimes if you've got an iPad or something and a phone going at the same time, that will cause an echo?
I'm not sure what's going on, but there's a lot of, let me try to log back in.
Okay. It's odd. How about we've got one other case. I'll take that real quick.
Okay.
And give her an opportunity to get logged in. Do we have anybody here on that matter?
I'm his grandmother.
Good morning.
Nicole Miller. Good morning.
All right. Okay, doesn't look like we have service of anything on this one. You know if the parties have been, or the parents have been served?
The mother was with me when we filed. The father, he's incarcerated right now and he has an order of protection. He tried to potentially kill the child last month and is in Lake County or in Cowlitz County. My daughter has suffered a relapse and mental breakdown and is going to be heading to treatment when she gets to that point, I guess. I don't know. So the father is not even on the birth certificate. I didn't know if I had to list him or not. He is in Cowlitz County Jail though right now. And CPS and the not detectives, but the prosecuting attorneys filed a no contact.
Okay, let me just check. Probably in this one. And is mother in agreement with this at this point?
Yes, she was with me when we filed all the papers. She signed we did the whole packet. I don't know what it's called, but she filed the paper that's in agreement with the guardianship.
Do
Signed
you see a consent?
yeah, but it's attached to the petition.
Oh.
It's the last page of the petition.
Give me just a second, then I was not seeing that. Okay, I do see that. All right, so at this point, do we have back the criminal history cover? I do not see the CPS information yet. I have an order.
No, I didn't. I'm sorry.
Okay, so mother has signed a consent, so she's covered. If he is not on the birth certificate?
No, the child doesn't even have his last name. He's not on a birth certificate. He's not on any documentation at this time. I was told by CPS that, you know, when he gets released, he's going to try to get a paternity, but at this point, he's not even allowed to be around him.
Mm-hmm.
So.
Okay.
He strangled him last month, and the baby was in the abuse hospital in Portland.
Okay. I think at this time, those are separate issues from the custody and guardianship, but I think until he gets himself established, this doesn't provide for an alleged parent until he's established to be father. So at this juncture, we probably just need to get the CPS records back. And it looks like that order's already been signed. I assume that's been submitted. We usually get those back fairly quick, but that was only a week ago. So why don't we do this? I'll extend the temporary order. Excuse me. Go here just a minute here.
Her yes, caseworker did attach a letter. I know that that's not the file, but I didn't know if you saw the letter.
I did see the letter, but there's a formal request that we send to them and they send back a packet of stuff.
Oh, okay.
Which we haven't received that yet. So I can't move forward on this today, but what I'll do today, I'll extend your temporary order. And probably we're getting those pretty quick now. So I would think if we went out 2 weeks, we'd probably be fine. Yeah. So I'll extend out the order to that point. I don't think with mom consenting, and I don't think we need a visitor and the child is 1. So I think at this point, we just need to get back that information from CPS so we can move forward.
Okay. My only concern is with this temporary guardianship. Am I able to, I just need to provide him with some medical over here to put him into daycare because I live in Montana.
I will include in the order that you have the powers for healthcare decisions, school, all that stuff. So it looks like it wasn't included in the last order, which is unusual, but I will include that in there. So you'll be able to get a copy of that order probably either later this afternoon or tomorrow.
Okay.
Okay.
And will that be through my email?
Do we send these out, or does she need to require a copy of this order?
Yes.
Okay. I assume we have your email on file? Yes. Okay.
You should.
All right. What I'll do, once we get this filed, I'll have court administration send a copy out to you.
Okay.
So the alleged father is a named participant in the case. You want to leave him in there? Or do we need to do an order removing him until paternity is established?
Let me look at the statute and then make sure, and I'll address that next week, next hearing. I don't know off the top of my head without. I don't think he needs to be in there if he's not on the birth certificate.
Okay.
Your Honor.
Yes.
In the Zoom booth and they're asking.
When I first started filing the papers, I was told he did not have to because he was not on the birth certificate. But then when I did my final paperwork, to get the emergency hearing, if she was of knowledge of who the father was, I was to list him. That's why I listed him. Otherwise, I would not have even put him on there because he is not on the birth certificate.
Okay. Let me take a look. I'll look at the statute before we get back in 2 weeks, and I'll have a better answer. I just don't know off the top of my head.
No, you're fine.
So I will look that up. But that question has not come up previously, so oddly. So, but I'll take a look at that. We'll come back on the 16th of April at 10:30. I'll include the healthcare provisions, and court admin will send you an email.
Okay.
Okay. Do we have?
All right. Thank you so much.
All right. So that will cover that one. Angie Rogers back in.
Yes. Can you hear me?
There we go. I don't know what changed, but we're not getting the echo now, so that's good.
Yeah, I don't know either.
Okay. So this one, Ms. Farr, you are involved in this one.
Yes, Your Honor. So this case is, the child was living with Ms. Rogers under an NPC order. Procedurally, that probably should have been converted to the guardianship to appoint a successor guardian instead of the way it was done, but the way it was done. So I think we need to just consolidate those cases, or maybe we need to convert that and then consolidate the two cases. I'm not sure how the clerk's office wants to do it. But the petitioners are the adoptive parents of the sibling of this child, and the child is no longer safe at Miss Rogers' home because of the biological parents. So the adoptive parents of the sibling have now filed for guardianship. There's still some procedures that need to be completed. They need to complete the lay training. The father needs to be served, and a long-term petition needs to be filed. So we're still kind of in the beginning stages. So I think we just need to extend this out to give them a little more time to complete those tasks.
Okay. I think on the conversion, I'm not aware of there being a provision that allows us to do that. I know some counties think there are, but there is no legal way to convert the third party to a type 4.
Oh, okay. Clark County does that routinely.
I don't think there's any authority to do that. I know we've had that discussion before, but so, and I don't think we can even consolidate necessarily, but once this petition takes over, that one could be dismissed.
Okay.
So, but I can extend this out. How much time do you think we need on this one to?
I'm going to say 3 to 4 weeks.
Do we have anybody objecting at this point?
No objection, Your Honor.
I'm sorry?
I said no objection, Your Honor.
Okay. And I'm familiar with this case. I've looked at this case previously. So, well, let's do this. Let's put it out 4 weeks. That'll give everybody time to get all the paperwork done. So that'd be to the 30th of April.
That's judicial.
Let's go 3 weeks then. We'll go to the 23rd. We probably don't have a docket on the 30th. I'd forgotten that. So the 23rd of April, that's 3 weeks out.
Okay.
And that'd be at 10:30, a Zoom hearing just like this one. In the order that we have in place, I'll just simply extend all the terms and conditions of that order.
Okay. Thank you.
Okay.
Yeah.
Thank you.
You are welcome.
Thank you.
I believe that is all we have on today.
Yes, Your Honor.
So we will adjourn.